cases. Good morning. Our next case is State versus Bowman, and we will hear from the appellant.
May it please the court. My name is Sherry Lawrence. I'm a Special Deputy Attorney General with the North Carolina Department of Justice, and I represent the state in this case. I would like to reserve 5 minutes for rebuttal. This case is before this court on the state's notice of appeal based on Judge Carolyn Thompson's dissenting opinion from the majority opinion, finding plain error in the trial court's jury instructions on 2 counts of first-degree forcible sexual offense. The only 2 charges at issue for purposes of this appeal are the 2 counts of first-degree forcible sexual offense. In this case, the Court of Appeals erred and did not follow this court's or their own precedent. The jury unanimously convicted the defendant on 2 counts of first-degree sexual offense. The trial court's instructions setting out the alternative acts the state had to prove to fulfill the sexual act element of first-degree forcible sexual offense is not fatally ambiguous. To determine whether unanimity requirements have been met, this court noted in Lawrence, Fowles, and Diaz that the examination of the indictments, the evidence in the case, the trial court's instructions, and the verdict may remove any ambiguity created by the trial court's jury instruction. In this case, there was evidence of a higher number of incidents than indictment charges sent to the jury. An examination of the evidence in this case, the indictments, the trial court's instructions, and the verdicts established that the requirements were met for unanimity. The defendant, as stated, was indicted for 2 counts first-degree forcible sexual offense. The indictments included all of the elements for the offense, but did not specify, and the state was not required to specify, the applicable sexual acts in the indictment. The evidence in this case, the prosecuting witness testified to 3 sexual acts, being fellatio, anal intercourse, and digital penetration of her anus. The trial court correctly instructed the jury on all elements for the first-degree forcible sexual offenses. The trial court instructed that the state had to prove that the defendant committed a sexual act. The trial court defined a sexual act as intercourse, anal intercourse, fellatio, and digital penetration of the anus. The jurors were also instructed that their verdicts had to be unanimous. The trial court instructed the jurors that all 12 members of the jury had to agree to the offense before rendering a verdict, and if they did not agree and find beyond a reasonable doubt that the defendant committed one or more of the elements, then they were to find the defendant not guilty. The jury's verdicts were unanimous. The defendant never objected to the trial court's instructions. The verdict sheets listed each offense separately with the file number and the count numbers that tracked the indictment language. At the end of the trial, all jurors were individually polled as to whether or not their verdicts were unanimous. All jurors affirmed that their verdict was unanimous. The record does not indicate or reflect any misunderstanding, any confusion amongst the jury, or their duty to render a unanimous verdict. An examination of the entire record in this case establishes that the jury's verdicts were unanimous and not ambiguous. Unanimity requirements were met. As additional support for upholding the trial court's instruction in this case and the defendant's convictions in this case, this court's opinions in Fowles, Hartness, and Lawrence are instructive. All of those opinions confirm that the first-degree forcible sexual offense statute only requires that the jury as a whole agree that the defendant committed a sexual act. The forcible sexual offense statute does not require that all jurors agree on the actual sexual act that the defendant committed. In State v. Fowles, the defendant was charged with first-degree sexual offense. The trial court instructed that the state had to prove that the defendant committed a sexual act. The defendant argued in Fowles that there was no unanimity because 6 jurors could have found oral and the other 6 could have found anal. However, this court upheld the defendant's conviction. noting that the jurors were clearly informed that they must agree on all elements before reaching a guilty verdict. This court stated that the instructions as a whole obviously required the verdict of not guilty if 12 jurors were not satisfied. However, this court stated that nothing in the record indicates there's any confusion, misunderstanding, or disagreement among the jurors regarding unanimity. In State versus Hartness, this court revived Faust because between Hartness and Faust, this court issued the opinion in State versus Diaz, which overruled Faust. However, Faust was revived by this court's opinion in State versus Hartness. In Hartness, the defendant was indicted for a number of offenses. However, the offense at issue was indecent liberties. This court again confirmed in Hartness that to establish the offense of an indecent liberties, alternative acts could be shown, and the jury did not have to agree on those acts.
Can I just ask you about that train of cases? Because it seems to me, I'm struggling with the notion that the fact that the jury was instructed that they must be unanimous means we don't have to worry about how they were instructed on the substantive offense, when our court itself, went from, as you point out, went from Faust to Diaz to Hartness. Like this court flipped back and forth on what the meaning of unanimity is in this context, and it seems to me that if the argument you're making makes sense, if there's one charge and multiple acts that each one could be satisfy that element, and in that circumstance, if some jurors believed act number 1 happened and other jurors believed act number 2 happened, so there weren't 12 jurors for each act, but because there's only one offense, together they found that the elements of the offense were met. I understand that logic. But if there's 2 offenses and 2 charges, it seems to me that it no longer holds, and that you have to have 12 people who believed that there were 2 different acts committed to constitute the 2 charges, the 2 counts, the 2 crimes. Do you follow me there?
I do understand, Your Honor.
So then that brings us to this case, where there are 3 acts and 2 charges. And it seems to me clear that as a matter of logic, that there's enough there for one charge. That even if 3 jurors thought one act happened, another 3 jurors thought a second act happened, and I think I'm now at 6 jurors thought the third act happened. If you have just one charge, they all together collectively found that one count of forcible sexual offense happened. But where you have 2, it's not clear to me that, sort of as a logic matter, that we can therefore conclude that there were 12 jurors that found both that there were 2 offenses that were committed. So how do we get to that logically, where there are 3 underlying acts and 2 crimes that are being charged?
Your Honor, I think the short answer to that is I think your scenario becomes a problem when there is no evidence to support all of the actual indictments. For instance, if the defendant is charged with 5 counts and there's only evidence of 4, then there would be some issues there, because there would be 5 charges but 4 actual acts. So the conviction on 5 could not be upheld. In this particular case, in Diaz, kind of going back to that history, in Diaz, it was a trafficking and marijuana case. And this court reconsidered Faust, overruled Faust. However, later on in Hartness, they recognized that, well, it's a different context. It's a different charge at issue, which I think is very important to note. Dudley is cited, State versus Dudley, which is an opinion from this court, is cited in the filings. And in Dudley, it dealt with a rape offense. However, is very similar to first-degree sexual offense. And in Dudley, this court stated that rape is not a continuous offense. So I would contend here, these are not continuous offenses, so therefore it would do away with any concern for um, which juror decided on cunnilingus versus which juror decided on fellatio if you have the amount of evidence needed for the indictments.
Well, but I think there's a challenge here because the indictments themselves have, for the 2 counts, have exactly the same language. So there's nothing there that distinguishes what the acts were. And if the jurors only found that one of the 3 acts actually happened, then he couldn't be guilty of 2 counts, right? So, but here the indictments don't specify which acts are in which count, and then the jury verdict form similarly doesn't specify that, and the jury instructions only gave the instruction for this offense 1 time. So it seems a challenge to then figure out what we think 12 people ultimately agreed on.
As this court has noted in its precedent, we look at the gravamen of the offense, the intent of the actual offense, and how the legislature laid out the elements. The legislature clearly stated a sexual act. Had the legislature wanted to box, I say practitioners in this court, and the legislature would have clearly laid out, as it has done in other statutes, such as the drug trafficking statutes, all those discrete activities within the body of the language of the statute itself. However, the legislature did not do that.
Right, and I think I understand how that applies if you're only charged with 1 crime. But when you've got 2 counts, that's 2 crimes. So just as in the trafficking statutes where it's transportation or possession, here there's 2 separate crimes. So there's 2 things that the jury unanimously had to find he did in order to find him guilty of 2 crimes.
Correct. And as long as each juror finds the gist of the offense is that a sexual act occurred. And again, I think the problem may come in if the jury finds more than the actual evidence supports, which would be a fatal variance issue. However, we do not have that issue here. So essentially the issue in this case is where the defendant was indicted for 2. There was evidence to support 3, but because of the nature of the statute and how the legislature has laid it out, the jurors could have found either act for either one. The gist of the offense is that each juror found a sexual act. And I think Dudley is relevant because, like rape, a sexual act or this offense is not a continuous transaction. And it is okay because of that.
So the majority in the Court of Appeals writes that the jury convicted defendant on both counts of first-degree forcible sex offense, which begs the question, which 2 sexual acts did the jury unanimously agree upon? And I guess my question to you is, what is your answer to that question in the majority?
My answer to that question is that the state is not required to select the act for the indictment. The legislature has been required the state to do so. In addition, in the verdict sheets, while it may be the better practice, the trial court or either party is not required also to specify the act within the verdict sheets. There was no confusion in light of the instructions. In this case, this court's most recent opinion in State versus Lawrence, which is from 2006, this court looked at the instructions and looked at whether or not the jury was instructed properly on unanimity. In this particular case, as in Lawrence, the jury was instructed properly. There's been no contention that there's any issues with the jury instructions and that they were not correct and that the unanimity instruction was not correct. And looking at all of those instructions, and he instructed them multiple times, we have to presume that the jurors followed the trial court's instructions. And if the trial court asked and instructed the jury to find those elements for the offense, and the trial court also instructed the jury as to both counts. And I know defendant states that the trial court, there's no evidence that the jury was aware of those two offenses, that it was actually 2 versus 1. However, there was evidence. The evidence was in the trial court's initial instructions. The trial court clearly stated the defendant is charged with 2 counts. In addition, on the verdict sheets, it specifically laid out each individual count for first-degree forcible sexual offense independently. In addition, in that language on the verdict sheet, it stated that we, the jury, by unanimous decision, find the defendant to be, and they could select their choices. Again, instructing them that their verdict had to be unanimous. This court has repeatedly in these cases stated, even before we get to the precedent, has the precedent regarding first-degree forcible sexual offense. This court has repeatedly stated and relied on the trial court's jury instructions. And the case law of this court expressly has stated that there's a disjunctive instruction in the context of these cases is sufficient. In each case, this court has looked at the jury instructions. There's no contention that the trial court or that the jury was improperly instructed as to unanimity. The key and the gist of this offense is that each juror, all 12 as the trial court instructed, had to find that the defendant committed a sexual act. And I think, as I stated, the only issue comes in if the evidence does not support it, which becomes another issue, a fatal variance issue.
In the appellee brief, at the end of the appellee brief, Bowman says, I'm paraphrasing a little bit, but in any event, if you reject this argument from the majority of the Court of Appeals, you need to remand for the Court of Appeals to consider the argument that I actually raised at the Court of Appeals. So my question to you is, everything that we're talking about right now, this question of jury unanimity, is that the argument that Bowman made to the Court of Appeals in the appeal?
No, Your Honor. That is not the argument. As I read it, I did not handle the case in the Court of Appeals. However, as I read the argument, it does not appear to be that. However, it is an instructional issue. So it is a very similar argument based on different precedent. In fact, in his argument, the defendant actually conceded to 1 count of first-degree forcible sexual offense. And as to the defendant's request to remand, the Court of Appeals issued an opinion as to the jury instructions, and the defendant acquiesced. There was opportunity for the defendant to file other filings, motion to reconsider before the Court of Appeals, motion for rehearing en banc, or even in this court, a petition for discretionary review or a petition for cert. The defendant has not done so. And this did not arise until the state filed this brief, because it's one of those situations where the defendant says, okay, I'll go with that opinion. However, I think it's also a situation where the defendant is trying to get that second bite of the apple, saying, well, I think I've ran into a problem with the precedent of this court, and I can't really distinguish it, so let's get the court to overrule this prior precedent, and now, if you don't do that, let's send it back. Let me try it all over again. And we would contend for this court not to accept that invitation. As to briefly address the defendant's new argument that the defendant raises here, requesting this court to overrule Fowles, Lawrence, Hartness, and Lyons, which the defendant does not directly make that request. However, that's essentially what the defendant is asking this court to do. That argument is not properly before this court. It wasn't a basis of the dissenting opinion or the majority's opinion. It was never discussed in the Court of Appeals. And again, we would ask this court to decline the defendant's invitation to overrule years of precedent of this court, going all the way back to 1984 with Fowles. In addition, I mentioned earlier that the Court of Appeals has held prior to this opinion in Scarborough versus Petty, The Court of Appeals has recognized this court's precedent and applied it and ruled in alignment with it. However, for this particular panel, they hitched on to Bates and decided to develop their own thing and ruled not in alignment with the precedent. And we would ask this court to affirm the precedent of this court by reversing the Court of Appeals and affirming the defendant's convictions. And in summary, the indictments properly charged the defendant with the counts. There was evidence to support all of the counts. The instructions were correct. The trial court instructed the jury as to unanimity. The verdicts were clear. He rendered a verdict as to 2 counts. They rendered verdicts on 2 counts. And we would ask this court to apply its prior precedent and reverse the Court of Appeals majority opinion. And I will reserve the rest of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good morning, Your Honors. May it please the court. My name is Aaron Johnson, and I represent Mr. Bowman. I'd like to start by taking up an issue that the state has articulated in its brief and this morning, that this is a plain error claim. This is actually not a plain error claim. When you have a claim that a verdict was fatally ambiguous, it's preserved regardless of objection because an ambiguous verdict is insufficient to support a judgment. And it's reversible for that same reason. So really this just comes down to the merits. And on that, the issue presented at this point in the case is whether Mr. Bowman was denied his state constitutional right under Article 1, Section 24 to an unambiguously unanimous jury verdict. The Court of Appeals took up that question and it answered it in the affirmative. And this court should, that holding should be modified and affirmed, or in the alternative, it should be remanded back to the Court of Appeals, as Justice Dietz was talking about.
Yeah, I appreciate the candor of your brief in sort of acknowledging what we would do in order to accept the argument, your argument, which I understand why you're making it, because yes, the Court of Appeal, the majority's made it, but it isn't exactly the argument that you made on direct appeal. I mean, you had a good argument on direct appeal, just it's not this one. Would you agree with that?
That is correct. We raised a different argument in the Court of Appeals than the one the Court of Appeals ultimately took up and used to decide the case.
So we do have that line of case law that says the Court of Appeals isn't allowed to do that. Do you think there's something about kind of how connected the theories are that means it's okay to take this up, or do we need to be restrained to just the arguments that you brought to the Court of Appeals?
Are you thinking about RAF in cases like that?
We just reaffirmed that in a case called Bottoms Towing just a few calendars ago.
So I am not making the argument that the Court of Appeals erred by taking up this issue and resolving it. I think there are kind of 2 different ways of looking at it. One is that the Court of Appeals raised it sua sponte, or more likely that they just misapprehended the argument that I made there. So getting back to the merits of this, as you were discussing earlier, this was a number of charges coming from a single incident, and in particular 2 counts of first-degree forcible sex offense. And Justice Earls, I agree. I don't think that it's possible to pair either verdict with any particular sexual act. The indictments were pretty much identical. The evidence showed more than 2 potential sexual acts stemming from a single incident. The instructions on this offense were given just once, and they lumped all 3 potential sexual acts in together without differentiating between them. And the verdict sheets, the jury returned general verdicts. It didn't specify which act was linked to which count. So under these circumstances, I think the Court of Appeals was right to say that they couldn't make that determination. The legal question is whether that matters, and we agree with the Court of Appeals that it should. This area of law is admittedly pretty confusing. It comes up every few years, and the Court of Appeals seemed to misapprehend the argument in this case. So if we were starting from scratch, I would say that we should adopt a rule, something like has been adopted in other states. We cited Alaska and Washington and Utah, and this would be a rule that would require the jury to be specific about which act or acts serve as the basis for the offense. And frankly, I think we should get as close to an approach like that as possible. Essentially, I think that we shouldn't have a jurisprudence or doctrine that allows for multiple B1 convictions stemming from a single incident without at least requiring the jury to agree on the factual basis for the charges. But I do recognize that North Carolina has taken a different tact. For most of these unanimity cases, we apply the Hartness or the Diaz tracts of cases. So let me say a little bit about why I don't think that should apply here. I think it's basically a poor fit for a charge like sex offense. And not because the offense doesn't cleanly fit into the tracts, but that it basically seems to fit into both. The offense is under 14-27.26. It requires a sexual act, and that term is defined under a separate statute. That's 14-2720. And so that would seem to place it within the Hartness line of cases. But it also appears to fit under the Diaz tract, where there is a unanimity problem. And let me quote from Lyons on this. Allows the jury to find a defendant guilty if he commits either of two underlying acts, either of which is in itself a separate offense. So that was in Lyons. That language was then quoted later in Bell, and then it was quoted again in Walters. And I think this fits within the Diaz tract because each separate sexual act can be the basis for a separate sexual offense. So it appears to fit within both. And I think Faust actually supports that. And let me quote from that one. The state's evidence tended to show the commission of two distinct offenses of first-degree sexual offense, to wit, anal intercourse and fellatio, and that was within a single incident. So that should have been enough to keep Faust within the Diaz line of cases. Let me make one more point about this, and the Diaz rule in particular. It's often discussed as if it applies only where there's ambiguity regarding two different types of offenses. It's actually a little bit broader than that, and it has been applied when you're dealing with multiple counts of a single offense. And I can point to two cases for that. One is Lyons, where the offense was malicious secret assault, and it wasn't clear which of two people had been assaulted. So there was a fatal ambiguity problem there, even regarding two different charges of the same offense. And I think similar support comes from this court's decision in State v. Hall and really sort of what happened to that case after that. In Hall, there were basically two back-to-back robberies at a gas station. And this court originally said that there wasn't a unanimity problem when the instructions failed to differentiate between them. However, Hall was then overruled in Diaz. And as far as I can tell, Hall has not been revived the same way that Faust was. All of this is to say that I don't think that sex offense really falls cleanly within either track, or rather more precisely that it seems to fall within both of them. So I don't think it's useful for resolving a case like this. And so I do need to be candid that for these types of offenses, I'm asking for a change in the law. And in particular, I'm advocating for a rule that would require the jury to be unanimous regarding the acts and not just the elements of the offense. Where the offense at issue is something like sex offense that can only be committed in a number of separate but discrete ways. And the second part of that, and I think this is probably more important, is where each discrete act can serve as a separate count of the offense. And this is especially useful, I think, where the charges arise from a single incident. That's kind of what makes this case different from most of the others. And so our basic idea is that the unanimity requirement should be robust enough to require the jury to differentiate between different charges, at least when they arise from one episode or incident. And to adopt an interpretation like that, I don't think this court would actually have to overrule any of its prior cases. I think that Faust is distinguishable on the basis that it was not clearly an Article 1, Section 24 case, though I do recognize that it has been cited in later cases that were dealing with Article 1, Section 24. So if you keep that rule limited to cases in which you have multiple charges arising from a single incident, I don't think you have to overrule anything. If you were to apply it more broadly, I think that one and potentially two cases would have to be overruled. To apply it more broadly, I think the one that would have to be overruled is McCarty, a case from 1990 that followed shortly after Hartness and did deal with sex offense. And the other one, I do think that Faust is distinguishable, but if you disagree with me on that, this court would have to overrule either Faust or, more specifically, the portion of Hartness that revived Faust and placed it within the Hartness line of cases instead of leaving it under the Diaz line of cases. So I do want to be candid that we're asking for a change in the law, at least for how a small group of these unanimity claims are evaluated.
So one thing I'm struggling with is, what's the policy interest that's served by your position? Under the current law, the jury has to find each element of the offense unanimously.
Yes.
Why go beyond that?
So why require it?
And because once they've done that, they've established that the crime has been committed.
So why should they have to be more specific and agree on the acts and not just the elements?
Right.
Essentially, I think that it would be a better rule, and it's one that other states have adopted. And it'd be better, I think, for a couple of different reasons. One is that the more robust the unanimity requirement, the more protective it is against either executive or judicial overreach. And those are two of the concerns that animate the unanimity requirement in the first place. And I believe the Supreme Court's recent opinion in Erlanger talks about that to some extent. But I think that there would be two other types of more substantial benefits. One is that I think it would help stem off potential double jeopardy concerns later on, because it would make clear what acts had already been tried and either resulted in punishment or an acquittal. Or the second thing that I think this would help with is that it would improve jury deliberations and decision making by requiring them to actually delve into the facts of the case. And there are two Supreme Court cases that talk about this a fair bit. One is Richardson from 1999, and the other is Mathis from more recently in 2016.
And wouldn't it also, or would it also serve the interests of making sure that people are only convicted of crimes that they're actually guilty of? In this case, was there not a hung jury the first time there was a trial?
There was a hung jury the first time. We don't know much about that because we don't have a transcript of the trial, but there was a hung jury in this case. And so that's part of it as well. And essentially requiring the jury to really dig into the facts and decide what they think had happened and what they think had not happened. Let me see, have just one more point about this. We should also note that this sort of rule would actually not be very difficult to apply in most cases. The specific act that serves as a basis for conviction could be specified in the jury instructions, or it could be specified on the verdict sheet, or both. But I think either one would work. And so I think I've covered most of what I wanted to say on this. I just have one more last point to come back to what we were talking about earlier. We did raise a different issue at the Court of Appeals. That issue has not yet been resolved. It wasn't addressed by the majority or the dissent, and it hasn't been briefed to this court. So I don't think it's properly here. And so we would ask if this court is not inclined to affirm the Court of Appeals with modifications, we would ask for a remand for consideration of that issue. And with that, unless there are further questions, I will reserve the remainder of my time. Thank you.
Thank you, counsel. Rebuttal.
In this case, dealing with this statute, it's important to look at the legislative intent of the statute. This court recognized in Hartness that these cases are different. First-degree sexual offense cases and indecent liberties cases are different from trafficking cases where the statute itself specifies and does list the criminal discrete acts that are required to meet the element for that particular offense. Those discrete acts are indeed an element of the offense. for this particular case involving first-degree forcible sexual offense, as well as for indecent liberties, the statute does not list the actual conduct as a discrete element of the offense. For this offense, first-degree sexual offense, the jury is required to find a sexual act. There's a definition in the statute as to what qualifies as a sexual act, and the jury is instructed accordingly on that. This court has stated and expressly stated multiple times that these cases are different. And we would ask the court to rely on that precedent and to apply that precedent and to distinguish these cases consistently, that have been distinguished consistently. In this particular case, even setting that aside, there's not a question as to whether or not there was a unanimous verdict. We have to rely on the trial court's instructions. In this particular case, the trial court instructed, as I stated multiple times, and we can't speculate as to whether the jurors actually listened to those instructions or not. This court has stated the jurors are presumed to follow those instructions. This court has also stated in those lines of cases that where there is no disagreement, there's no misunderstanding, or there's no confusion, then that's noteworthy and that it was proper and the jurors unanimously agreed to their verdict. That's what we have here. We have those instructions on unanimity. We have no indication otherwise that the jurors disregarded any of those instructions. And based on all of that, I think it would be, considering this court has continuously since 1984 enforced this same precedent, it would be definitely a stark reach to overrule prior case law. And this court would have to overrule a lot of cases, not just McCarty. If this court has to overrule McCarty, it also has to overrule Faust. If this court has to overrule Faust and McCarty, they also have to overrule Lawrence as well as Harkness and restructure the entire law of North Carolina without the legislature imposing such a requirement. Again, the legislature has not imposed that requirement in the statutory language. And we would ask this court to decline the defendant's invitation to restructure the law where the legislature has not signaled otherwise. And we would ask this court to follow its very express and clear precedent and reverse the Court of Appeals opinion in this case. If there are no further questions, the state will rest on its brief.
Thank you, counsel. Thank you both. Mr. Clerk.
All right. Yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until the next calling of the calendar. God save the state.